All right, welcome to class, everyone. I apologize for doing this over a video recording instead of live over Big Blue Button. Big Blue Button was not working for me, and I didn't want you to have to wait and not be able to get on until later. So I wanted you to be able to view this during your normal class time. So I'm sending it to you. I'm recording it now and sending it to you um, right away, so you can watch it during your normal class time if you have that time already broken up. So that's the plan. Um, Today we're covering Chapter 9, which is the American legal system or the courts. We call it the judicial system, but a lot of people have a hard time with the phrase judicial system, so sometimes we just call it the court system or the American legal system. All right, after you read this chapter, you're going to be able to describe the role that law plays in a democratic society. So basically, we follow what's called the rule of law, that law takes the utmost precedent. Law can govern anyone, right? If I break the law, I'm held just as liable as if Donald Trump breaks the law, right? If same law, okay? Theoretically, that's how it's supposed to be. Whether it is, I mean, it's not really, but it's better than a lot of countries. Let's put it that way. It's better than most countries. So I'm pretty happy. Discuss the role of Congress and the Constitution to establish the judiciary. We're going to talk about federalism and dual courts. We call that conflict of laws. That's something I took an entire course about in law school, just called conflict of laws. We're going to outline the institutional roles and political influences that shape the Supreme Court and the decisions that it makes. And then we're finally going to describe the relationship between American citizens and American courts, right? Because not everybody has the same relationship, right? So the law is designed to provide security. It's designed to provide predictability, right? We kind of have the predictability that we can go about 5 to 7 miles an hour over the speed limit. If all of a sudden we got a highway patrolman who pulled us over for 2 miles an hour, we would be like, whoa, what's going on? I mean, technically the highway patrolman could do that, right? Technically the highway patrolman could pull us over for going 2 miles an hour, but there is a certain amount of predictability. Likewise, it provides security. I have children that walk home from school, so if someone's going 10 miles an hour over in the school zone, I want there to be security from the American legal system that this person will not be able to do that, right? It's also to resolve conflict. That's both criminal conflict or conflict between two private people, right? Just two people, let's say they're suing each other over a disputed will. We're also supposed to reflect and enforce conformity to society's values, right? So a lot of people are like, oh, the stinking law, it's all based off of Judeo-Christian values. Well, of course it is. Of course it is, because our law was created in a day when society's values were based largely on Christian values, and that remnant still exists. In fact, a lot of Christian values still exist in America today, whether people like that or not. That's the way it is, and so the law is going to represent that, right? It's also designed to distribute benefits and rewards that society has to offer, and to allocate costs for those things. All right, so we have what's called the common law tradition. That's a legal system based on the accumulated rulings of judges over time by judge-made law. So basically know that common law tradition is judge-made law. Okay, so it's not necessarily written in law books, it's not, the word we would use is it's not codified, it's not written in statute, but it is made over time by judges' opinions. Now, we talked about that we want predictability, right? We talked about predictability here. The predictability is exampled in our precedent. Now, judges are supposed to base their decisions based on earlier decisions. So if Roe versus Wade was challenged and a woman's right to an abortion was challenged, according to precedent and the common law tradition, abortion should remain legal, right? That's if it's followed the way it's intended. Now, there could be a case that is slightly different that might change the facts, might change the ruling, but if it's based on its merits, it should be about the same. All right, we have substantive law versus procedural law. Substantive law is a law that the content or the substance defines what we can or cannot do. You cannot murder someone, okay? Now, it doesn't matter if you shoot someone in the head, the law is you can't commit murder, right? But let's say there's a procedural component to this, a procedural law. So let's say you walk up to someone on the street and just shoot them in the head. Well, that's murder, right? And you're going to go to prison for a long time. However, let's say someone was coming into your house and you shoot them in their head. That's self-defense, right? And so procedurally, it changes the way the laws are applied, right? The law doesn't change. You can't kill someone. But procedurally, that law changes just a little bit, enough for you to be held innocent because it was self-defense, right? Then I alluded earlier to this idea of criminal laws versus civil laws. Criminal laws are laws that prohibit behavior the government has determined to be harmful to society. So those are laws that are harmful to society as a whole, okay? Let's see here. Move this a little bit. Those are criminal laws are a crime. Civil laws they regulate interactions between two private people, two individuals. Now that's not called a crime, it's called a tort. Let's go back to shooting someone in the head example. If I were to shoot someone in the head, I would be held in for criminal law for murder. However, let's say in civil law that the person who I shot, let's say his wife, brought a civil claim against me for it would be called wrongful death or a tort. The wife wouldn't bring a claim against me for murder and to try to put me in prison. That's the state that does that. That's the government that does that. When it's just between private actors, that's when it's a tort or a civil claim. All right, we have constitutional laws. Those come from both state constitutions and U.S. constitutions. Statutory laws from legislatures. That's the U.S. Congress and state legislatures. We have admin laws. That's from bureaucracy, and that's a whole other ballgame. We won't go into that too much. Then we have executive orders. That's from presidents and governors. And executive orders are kind of those are the controversial thing. If you'll recall the Saturday Night Live sketch that I played about Obama pushing the law down the steps of the Capitol and just embracing the executive order, that's what that is right there. It's law that technically shouldn't really be. It shouldn't have the same effect as law because it's not voted on by a multitude of people. In Federalist number 78, Hamilton argued that the judiciary branch was the least dangerous branch, that there was nothing to worry about the judiciary. Now we have people voting for president based on who they will appoint to the Supreme Court. Think about how many people that you know, I know several, probably dozens, that voted for Donald Trump. And when I asked them why they were planning on voting for Donald Trump, a lot of them said, well, I want them to appoint a conservative justice. That's my whole goal. And so far they've gotten that. They have got a conservative justices, right? So good. That's exactly what they got. But so what I'm trying to say then, it is considerably more powerful than Hamilton argued in Federalist number 78. And the reason why it became more powerful is a man by the name of John Marshall. He was one of the earliest Chief Justices. He established in the case of Marbury versus Madison, a very important case for you to know. Marbury versus Madison for the test. A concept called judicial review, that the power that the courts would have would be able to determine whether the other branches were following the Constitution, whether a presidential act or a congressional act was constitutional. And if it wasn't, they would be invalidated, right? So, jurisdiction. Jurisdiction is basically whether a court has the ability to hear a case. So the first level is called original jurisdiction. That's where it's kind of this is like a trial court, right? When you first hear the case, this is the U.S. District Court and the state trial courts. Then we have courts with appellate jurisdiction. That means, well, I don't like what the trial court said, so I'm going to appeal it to a higher court. Now those courts are U.S. Courts of Appeals, the U.S. Supreme Court, the state intermediate appellate courts, and state Supreme Courts. Now, courts with both original and appellate jurisdiction is U.S. Supreme Court. Now, the U.S. Supreme Court functions 99.5% of the time on appellate jurisdiction. Very rare is it original jurisdiction, but it does have that opportunity for diplomats or conflicts between the states. The state structure is the same: trial courts, appellate courts, and state Supreme Courts. Some call them, they might have different names, but the structure is the same. So like I think New York uses the term the superior courts, and that's like their middle courts, their appellate level courts, not their Supreme Courts, but you get it. The federal court system has 3 levels. You have 1, the federal district court, 2, the Circuit Court of Appeals, and the U.S. Supreme Court. So Utah has a federal district court, but if we want a Circuit Court of Appeals, we have to go to the 10th Circuit, which is in Denver, Colorado. That's where we would have that. And there's 13 different courts of appeal. The U.S. District Court, there are 94. They hear both criminal and civil cases, and their juries, and at the district court, the juries are responsible for the verdict. So at all lower levels, all courts with original jurisdiction here, they can have a right to a jury trial. And most of the time, they'll have a jury trial. Then we have 94 district courts. Each state has at least 1. They hear both. And then for the appeals courts, those are arranged into 12 circuits. You have 12 circuits plus the 13th is in Washington, D.C. And those are solely appellate jurisdiction. Now, there is no new evidence. There is no new witnesses. Okay? You don't hear the facts again. These are basically rulings based on law. How are the rules based on law? Selections of judge. States, they vary by state to state. Some are appointment, some are elected. In federal, all federal judges are nominated by the president and confirmed by the Senate. And they serve for life. So they're there for life. I mean, as long as they want to be there, they're there. So that's one of the reasons why we're so careful about appointing a Supreme Court, right? And why there's such a rigmarole to getting nominated and approved by the Senate. Members of the court are selected based on criteria, their merit, their political ideology. Do they have the same views as the president? The president wants to put in a Supreme Court or a federal court judge based on if they agree with them. Sometimes they do it as a reward for good behavior. Sometimes it'll be just because they want to be confirmed by the Senate. All right, the Supreme Court is able to choose which cases they hear. They petition the Supreme Court. The law clerks are kind of the ones that pass it on. They're the gatekeepers. Law clerks are basically just recent law graduates. Then we have the concept called the Rule of 4. Now, that's not an official rule, but that's what they all have it. In order to grant cert, which certiorari is the ability to be heard by the Supreme Court, then you have to have 4 of the 9 justices agree to it, okay? Deciding cases, there's judicial activism and judicial restraint, and that's kind of a really big concept that we don't have really a whole lot of time to talk about. Basically, just know this. People that believe in judicial activism think that the court should go out of their way to resolve conflicts based on modern policy, whereas judicial restraint says, no, we should always adhere to what the Founding Fathers said and not interpret anything else into what they word. And so basically, activists believe that the Constitution is a living, breathing document. Judicial restraint believes that they should be applied only the exact same way that the Founding Fathers said. All right. Okay. So one of the benefits of having this recorded lecture is that we go by quite a bit quicker. And as you might need to play it a couple times. I went through the material relatively quickly because I couldn't stop to see if you had questions or anything like that. So I understand. Please contact me if you have any questions. Please send me an email. Let's see if there's anything else. Again, please do not hesitate to message me if there's anything that's unclear. I want to make sure that you're comfortable with all of this information that you received because it might have been kind of a little bit of overload. But you do have your discussionary, your participatory discussion due today, and look forward to reading those. Look forward to seeing you on Monday. Again, or Monday or Tuesday, and I look forward to seeing you. Thanks, guys. Have a good one.